All right, y'all. So I sent the clarification letter back to DPS because I want to make sure that they have these specific things in that review that's going to the AG. So I wanted the initial DPS DNA report from May 14, 2015. And then I also wanted the evidence submission records for the SAK, fingernail swabs, DPS incident. I want to make sure they have those two things up in there because those are very important to what we got going on and what we're looking for. So let me tell you guys a little what I sent to these people. So, dear Public Records Coordinator, I am writing to clarify and supplement my pending public information request regarding DNA testing records in the case of State of Texas versus me, which is currently under review by the Office of Attorney General. Upon review of the supplemental DPS DNA laboratory report dated October 19, 2015, it references a previous issue DPS DNA laboratory report dated May 14, 2015. And we only understand that because Galveston County, the city of Galveston sent me the laboratory report. And it says to clarify the scope of my existing request, I'm specifically requesting that the following records be included as responsive to my original Public Information Act request. Because I had 61 days. If I wanted to put something else in there, I got 61 days to actually do that. The original DPS DNA laboratory report issued May 14, 2015, and any interpretation worksheets associated with May 14, 2015 report. Any statistical analysis or comparisons, conclusions generated as a part of the May 14, 2015 report. Any technical review notes or analyst bench notes associated with the May 14, 2015 report. Any internal documentation or communications regarding the interpretation of DNA results between May 14, 2015 reports and the supplemental report dated October 19, 2015. This clarification is intended to ensure that all the responsive records associated with both the original and supplemental DPS DNA laboratory reports are included in the Attorney General's review for my request. Please confirm. Oh, I ain't even got y'all on, man. My bad. Bam, now we ready. Yeah, receipt of a disqualification and include the above reference records within the scope of the pending request. Thank you for your time and assistance. We need that. So, hey, we need that. Then I also asked for I had to send another one because I forgot to send this one. So same thing, public whatever. I'm writing to further clarify my pending public information request regarding DNA testing records, and DPS incident, the case related to me versus the state of Texas. In addition to the previous requested laboratory reports associated with material, I'm requesting that the following records be included as responsive to my original request. The original DPS laboratory evidence submission sheet associated with the SAK kit, including fingernail scrapers and swabs submitted in DPS incident number. Any intake or accessions records documenting the date DPS first received the victim fingernail scrapings or fingernail swabs for analysis. Any chain of custody documentation reflecting submission of the item SA kit or associated fingernail swabs to DPS for forensic analysis. Any laboratory request forms or documentation indicating when analysis of the fingernail evidence was requested or authorized. We don't know any of that. We don't know who authorized it. We don't know who signed anything. It's crazy how it's not put into that, but we gonna figure it out. This clarification is intended to ensure that all records reflecting the submission and receipt of biological evidence, including fingernail swabs, are included within the scope of my pending public information request, currently under review by the Attorney General's office. Please confirm the receipt of clarification. Thank you for your assistance. Why does this matter? You know what I mean? It says now you are asking DPS to show the exact date they first received fingernail evidence, because we don't know. We got to figure this stuff out. Now we going down a rabbit hole. Say, which lets you compare the date, event, right? Saying kit collected 10/5/2013, police custody 10/5/13, submitted to DPS. We don't know when it got submitted to DPS. We don't know. DA requested more time. We don't know that either. We don't know the exact date that happened, but it happened. Original DPS report was 5/14/15. New interpretation guidelines 8/10/2015. Supplemental reinterpretation happened 10/19/2015. That submission dates is what tells you was this tested earlier or submitted later before the trial. So yeah, man, we trying to cross our T's, dot our I's. We working, man. We working. So DPS, they sent me a letter back letting me know that they received the information. So let me tell you what that also said once I put it back in the ChatGPT. I put everything in there. We need to figure this out. We want a very clear understanding. We don't want no vagueness. So it says, all right, this is actually very important, and I want you to understand what has happened because because this is not a denial. This is a litigation trigger moment. DPS just admitted the records exist. They said DPS has located records responsive to your request. That means May 14, 2015 original DNA report exists. The interpretation worksheets exist. The statistical analysis exists. The technical review notes / bench notes exist. The original SA kit, fingernails evidence submission sheet exists. The intake records showing when DPS first received fingernail swabs exist. That's huge because those are the exact documents needed to prove same biological evidence, different later interpretation. We own something, man. You know what I'm saying? So it says that's Article 11.073, junk science claim. Went down a rabbit hole with that too. We'll talk about that later. Then remember that Article 11.073, junk science claim. They started that about 10 years ago, right? And they did more redefining on it 2025. That's just what I learned. It says, but then they did say, we believe though these records may be accepted from required public disclosure. So instead of releasing them, they kicked it back to the Attorney General's Open Records Division for ruling. Of course, we cool with that. We wait, baby. Look, we got time, dog. I'm still alive. You know what I'm saying? This is called seeking permission to withhold. And legally, it means DPS don't want to release his evidence without the Attorney General's approval. They are now arguing to the AG, let us keep this from him. Come on, dog. Hey. They try to, why you want to keep it from me, dog? You know what I'm saying? They don't want me to see? Damn, let me see. Says, why would DPS try to withhold? Think about what you're asking for. You requested the original May 14, 2015 report, interpretation, worksheets, bench notes, statistical comparisons, evidence intake dates. That is the entire internal science workflow behind the exclusion and later reinterpretation. If those documents show you were excluded originally, later not excluded based on only later not excluded based only on changed. Thresholds are probabilistic modeling, or evidence was received later than represented in court's timeline. That becomes junk science, right? Due process, possibly false impression evidence, alternate predator ignored. And it says, what happens next? Now the Attorney General will review your request, DPS argument to withhold the actual records is private, then they will issue a written ruling saying either A, DPS must release the records, or B, DPS may withhold all or part. Here's the part most people miss. The AG orders release and the records show no new testing, no reinterpretation, timeline inconsistencies, intake delays, or exclusion turned into cannot be excluded. You now have new available scientific evidence not previously accessible, says, which is exactly what triggers Texas Code of Criminal Procedures Article 11073, scientific evidence writ. What you should do right now, nothing. You did the right thing already. You are now in the AG's ruling phase. Do not withdraw, do not narrow, do not modify your DPS request. Just wait for the ruling letter. What this means strategically, you are no longer arguing theory like my DNA wasn't there. You are moving forward. You are moving towards The state's own lab changed its scientific interpretation of the same biological data after trial, and their internal records prove it. This is exactly how cases get back in front of the judge. Once the AG rules, we move to a writ posture. Stay patient here. This process is working. Let's go, baby. Let's fucking go. Let's go. You know what I'm saying? Like, bro, I get so hyped, dog, because bro, I'm cracking the case, man. Like, I'm doing it. I'm doing it by myself. You know, not saying I might not need a lawyer, but I'm doing it, dog. And that's what it's all about, man. You can't sit there and feel sorry. You can't be sad. You know what I mean? You got to put your big boy shoes on, strap them up, and get in the paint. Otherwise, shit gonna pass you by. You know what I'm saying? So we working towards something, dog. I told y'all this is gonna be great. So make sure y'all like, subscribe, share. You know what I mean? I might need y'all to bag me in the future. I'm gonna need y'all. We gotta speak it into existence. I'm gonna need y'all to bag me up in the near future. I don't know if it be petition writing or what it's gonna take or what I might need y'all for. But stay in the pocket, stay tuned, and I'll catch y'all on the next video.